Yeah, thank you very much, Mila, for these very kind introductory words. I'm going to share now my screen, and I hope you can all see the slides. If I can get a heads up from one of my colleagues that that's the case, then I'm ready to start. Thank you very much. It's really a pleasure to be here and joining, among other colleagues, the three sessions with you. Today we are talking a bit introductory and in general, and I wanted to start talking about the general equality law framework. And after your lunch, I hope you had a good lunch. What better way to start this with an image, which I will describe for those who cannot clearly see it. It's a search engine, and imagine that you yourself, you type into your search engine how to combine fatherhood and work. What the autocomplete function, so the algorithm behind the search engine, might suggest you is something like how to combine motherhood and work. But that's not what you were asking for. You wanted to know more about fatherhood and motherhood. And that's an old example I'm using since 10 years, and it's a real case, a Dutch father looking for this information on the internet. And it shows quite nicely, that's why I'm still using that even in the age of LLMs and sophisticated AI systems, that our society is biased, and biases and stereotypes can be found in the data sets. And that's one of the main problems, as we will see, and as will more later in technical terms be also explained by my colleague, Dr. Aaron Siros. So the question you as civil society and equality bodies you need to ask is, when is actually the threshold of a discrimination crossed? Because of course, we might not like it, it's not good in terms of policy, but is it legally relevant to grasp? I've wrote, if you're more interested, about this distinction between when a discrimination in the legal sense is actually there in an article here. If you're interested, we're going to share the material later on. But when we talk about biases and stereotypes, I want to give you two examples. So if you type nurse in your search engine, you look for images, you see something like that, mostly women. And if you type CEO, you see mostly that, mostly men. Again, two good examples that are very illustrative of the biases and stereotypes we have. But now again, I ask you all of here in the webinar, is this problematic? We don't like it. Of course, we as discrimination or equality experts might find this very disturbing. It's not good. But does it cross the legal threshold? That is the question. So now, but what if what we just saw, the data sets that I used contain biases or stereotypes? If these data sets are used in an AI system, it becomes more concrete. It will affect real people. And we see that that leads to a discrimination based on a protected characteristic like religion or race or gender, sex. Then it can become a problem. And here we in the typical case that civil society organizations might investigate, that equality bodies might be looking into. A good example would be an AI recruitment tool that is discriminatory towards a specific group, for example, women. That's a case that also happened in the real world. I just wanted to share this with you to kind of set the scene for the general tools of anti-discrimination that you have. You are all experts of discrimination law, so I don't want to go into the details here, but I would like to recall a few things that might be useful when you are confronted with a case of AI-based discrimination. And we all know there is direct and indirect discrimination, and we just need to be aware of that both could be useful for a case of algorithmic discrimination. Direct discrimination, I just recall, could be if an employer does not want to hire men, for example, and indirect discrimination could be a case where there is a neutral rule, apparently, that says there is a minimum height requirement to become a member of the police force. That's a real case, the Kaliri case from the ECJ. So that's the distinction between direct discrimination and indirect discrimination, and that becomes relevant. That is just the definitions of one of the equality directives. You know that. You can look into it later on. I just wanted to show the distinction between these two concepts of discrimination because it can make a difference in practice when you're dealing with a case, because indirect discrimination can be justified. So you would to look a little bit more deeper into it than potentially for a case of direct discrimination. So even though under discrimination law from an academic point of view, it doesn't really make such a big difference because both are covered. But from a practical point of view, also from an academic point of view, it makes a difference. But from a practical point of view, you might have to look a bit further in terms of evidence why this is justified and therefore not discriminatory. If you want to know more about it, there is the Adams, Pratzel, Binz, and Kelly Life article that nicely describes how algorithms can be directly discriminatory. Objective justification is something that could happen in indirect discrimination cases. So that is something you always need to ask yourself when you take your classical arsenal of the non-discrimination rules and when you are confronted with a case or you want to investigate a case or build a case, because it all comes down also to proving it, the burden of proof, does it shift? For example, in an employment case, does the burden of proof shift to the employer? If you have a prima facie, so a little suspicion of a discrimination case, all of that is important in the discrimination world, but also in the AI-based non-discrimination world. So you need to be aware of these things. And I'm flagging some of the things that could be useful in your daily work. We're going to go into the details, me and the colleagues, tomorrow and in the second and in the third webinar as well, and a little bit later on. If you want further reading, these are some suggestions. Notably, the Artificial Intelligence and Human Rights by Oxford University Press. You have a lot of chapters there on equality, different grounds of discrimination. You're going to find what you need. Another thing I wanted to mention is positive action. We all know positive action is possible under EU law, under certain conditions. And I mention this because traditionally we focus a lot on regulation and enforcing algorithms and AI. We kind of fight against them, but there could also be cases where AI could be used for the good to ensure equality and non-discrimination. And so we need to be aware of that, how this can happen. For example, you could use AI in an AI recruitment tool to ensure that an underrepresented group comes in the next round to facilitate the recruitment of the candidates. And we also need to be aware of this could, of course, be misused. So we need to be aware of these things potentially being used in order to address them and check whether there are problems with discrimination law. So again, going back, discrimination law in the EU, we all know the principles since the EU treaties. There are many EU equality directives. I don't want to go into the details here. It's basically just serve as a message to say, use the tools and the directives and your national laws that you have that is out there, because all of that obviously applies in the context of algorithmic discrimination, AI-based discrimination. So make sure that you use that in addition with new tools such as the AI Act, of course, but you can use these tools. It's just a new situation that you arise. I just want to emphasize that. You probably all know that, but please make use of all the tools, complaint mechanism, investigative tools, all your creativity that you have. It is very helpful in a case of AI-based discrimination. There's a lot happening out there, and sometimes it's a bit difficult to also keep the overview because not only the EU is doing something, the whole world is doing something. You all followed the debate in the US where there was a very good executive order that applied to the public sector on AI that was repealed recently. So there is this protection that will not be available there anymore in the US. There is in the EU the AI Act that you all know about, but also the Council of Europe is doing something. And you should never forget that the debate in the Council of Europe has a great influence because all the members of the EU are in the Council of Europe. And so it will be, once signed and ratified, directly binding law also in the member states. And the advantage of the Council of Europe debate is also that this, there was last year on the 17th of May, there was the Framework Convention that was being adopted. And this can be signed by other member states other than in the Council of Europe. For example, the US, Canada, Israel, all nations that do a lot of AI work have signed the AI Framework Convention, so it goes even beyond. And that could be potentially interesting if you, as a civil society organization that operates beyond Europe, or as an EU equality body that investigates and has to deal with a case that is also influencing another country or comes from another country, this is maybe important to know that it's not only EU law that could play a role here to kind of understand certain behaviors or to do investigations to get help from others. So I mentioned that legal landscape for the AI, look beyond Europe. And notably, there is not only the AI Framework Convention, but there's also for all of us very interesting the ongoing work on equality in AI. There is a draft recommendation that is being currently under work. The last meeting, I believe, was not in February. There was another one I didn't put here on the slide. So that's progressing. It will only be soft law, but it's interesting to follow that. Some of that is also available online. You can see the notes and the agendas on the website. So keep your eyes open if you want to be inspired. What could be the future legislative framework also in the Council of Europe. I wanted to continue with some bad news. The new commission, as you all heard, always doing new things, but they're also withdrawing some of the things. So they stop some of the legislative projects that they did. And one of them is the AI Liability Directive that was proposed by the Commission. And I think that's a missed opportunity, because if we think in terms of anti-discrimination law, of AI Act and other tools, consumer law that we have, the AI Liability Directive could have been potentially something that would be complementary, where victims of discrimination maybe could rely on. And so it's a pity that this has been withdrawn. And in the same vein, in the same document, as you all probably heard, also the 2008 proposal, the equal treatment between persons irrespective of religion, belief, disability, age, or sexual orientation, is also for the moment proposed to be withdrawn. And that's also bad, because any ground that you in the future don't have under discrimination law could not be relied upon in the context of AI-based discrimination. And that's, of course, a pity. So the less we have there, the less ideal it is for enforcing AI and discrimination. So that's a pity. But of course, some member states do have rules on that. And so basically only in this case, only in the scope of employment, it would be protected, but not outside of employment. That's a pity. Now going to the two main things that we're going to talk about, the classical anti-discrimination law and specific rules, the AI Act. I wanted to remind you as well that you should always think, what directives do we have in Europe? What are the national laws that I'm dealing with to prepare a complaint or to enforce my non-discrimination case on AI? And there you need to think, maybe some are more relevant than others. Always look into the directive on goods and services. Even though there are some exceptions in there, they might be highly relevant because they deal with a lot of things, goods and services that could be offered in the online world. And so very often AI systems are behind that. And then the specific rules of the AI Act. You know all that the AI Act is not an instrument on equality, non-discrimination, but indirectly it supports or could support non-discrimination law. There are a lot of interesting provisions that we're going to talk about in the 3 sessions. And I'm going to try to draw your attention to some of them. Of course, it's very detailed and participants have many different questions, but the idea is more to flag the general things, and then you can dive deeper. And of course, we will also have Q&A sessions to deal with your questions as far as we can. So diving in the AI Act, one of the key instruments that could be useful for the purposes of our seminar, the AI Act. As if you look into Article 1, of course, the purpose is not protecting equality, non-discrimination. The main aim is more internal market regulation. It's product regulation in the classical sense as you know it. But also one of the aims is, and that is what Article 1 says, is to ensure a high level of protection of fundamental rights against the harmful effects of AI systems in the Union and beyond. And so here we have it. Actually, it is one of the aims. It's maybe not the central aim of the AI Act, but it is there. And if you look then further, I invite you to look at the relevant articles that are in connection with the topic of equality and non-discrimination. There are quite some interesting provisions out there, starting with the equality bodies, Article 77. All of you know that. It gives potentially the power to an equality body, even equality body is designated, as a body to investigate fundamental rights and their specific powers. We will come to the details in the second session. There are more substantive provisions like Article 27 about a fundamental rights impact assessment under specific circumstances. There's Article 10 that foresees a bias audits under specific circumstances. That's only for high-risk AI systems. So that's Article 6 and the Annex 3 that is very relevant in this context, because these are the AI systems that have the most complex regulation, I would say, under the AI Act. And there are some other things that you might want to look into. There are a lot of recitals actually who tell you a lot about equality and non-discrimination, even though not the same as the operative part of the EU AI Act. It might be interesting to look into that for inspiration or arguments. And on the next slide that you can look in more depth when you're at home, it's a kind of a reading guide. You see some of the articles that are a bit more relevant than the others. It doesn't mean that others are not relevant. There are also some of them that are not here, and many selected recitals where you find information on non-discrimination and equality law. So with this, I want to now move slowly closer and prepare also the next presentation by asking, because we're in the legal framework here, what is actually an AI system? We talk now for a few minutes more about the legal framework, but the main question is you need to know, what is an AI system? When am I actually in a case of algorithmic discrimination, and when, as an equality body or civil society organization, do I want to investigate something? And so we look into the legal definition of Article 3.1 of the AI Act. It's a definition that comes from the OECD. And now just recently in February, the Commission even issued a 12-page document that tries to further specify what is an AI system. So it seems it's not so complex, but from a technical point of view, Aaron will tell us later what these AI systems specifically are. But just very briefly, I don't want to read it all, but the definition of the AI Act has basically 7 elements. So it's a machine-based system. It's designed to operate with some autonomy. It may exhibit adaptiveness. It can be explicit or explicit objectives. And most importantly, it infers from input. That is what you basically need to bear in mind. From inputs it receives, it generates outputs. And that can be a prediction, a content, a recommendation, or a decision. AI recruitment, or for example, something you see in your search engine. And then it needs to influence the environment. So here are a few more reading suggestions that you will also see in the slides, and we're gonna share with you. This is specifically on bias, discrimination, AI, and discrimination, two very interesting and accessible reads. But I wanted to just show you this in passant, because there are 3 more things I wanted to share with you before the first part on my side is over, and that is the risk-based approach of the AI Act. The way the AI Act operates is basically saying there are different categories of risks, and some are acceptable and some are not acceptable. And so you can distinguish these in 4 categories. There are the unacceptable risk, that's basically prohibited. I'm simplifying here, of course. The high risk is where there's more comprehensive regulation, such as high-risk AI systems like AI recruitment. Then there is a category of limited risk, where there are some transparency requirements. And then there's the minimal risk, where basically there are no obligations. So this is the way more or less this is structured, and this is important to know for what are the obligations of the AI Act and what could potentially be helpful in a case of a discrimination case. Just to share this on the way, because this is a quotation: biases remain endemic across technology processes and can lead to harmful impacts regardless of intent. So very often it's actually not intended, but something is still happening. And so it's still relevant for the purposes of non-discrimination law. This citation comes by the National Institute of Standards and Technology. And some of you might have heard that this is under threat currently in the US as well. So 500 people might lose their jobs, and they are there for standardization. We're going to learn about standardization in the 3rd session, notably by our principal investigator, Professor Karen Young, and our colleague Patricia Shaw, who will show us a few things on how EU standards operate with the AI Act. That just as a kind of preview. And now I want to finish with kind of the entry doors for AI-based discrimination. Some of that we saw already, but I wanted to flag that, to simplify, there are 2 ways how a discrimination can actually arise, or a biased decision, and that's either in the design of the AI system or in the biased datasets. That you need to remind, and we might come back to the cases. I have 4 short cases that illustrate that. For the design of the AI system, where kind of the design, the algorithm is designed, would be problematic is the Austrian case, where the labor market service used the case to distinguish who gets certain benefits or not, and what are the chances of reintegration into the labor market. And their valuables were used that specifically said this is only used for women, caring responsibilities, and that was problematic. So it could be if you use a specific variable that excludes or includes an underrepresented group that is protected under EU law, that could be problematic. The Syria algorithm in the Netherlands was another example. And for data sets, you could think of the famous Amazon case, where historic data sets were used that favored or did not favor one underrepresented group. And in this case, women were disfavored. And so here the data sets was playing a role. The same for the AMS chatbot, again, an Austrian kind of ChatGPT-like system, where the data sets that were used were a little bit biased and led not a discrimination in the legal sense, but the outcome was very much not in favor of women, because they were recommended with the same profile. A woman got recommended to go into gender studies, the travel industry, whereas a man were recommended to work on airplanes and do engineering work. So that just as an example to kind of set the scene. We might come back to that. And with that, I'm finished on my side, and I would like to give the word